The first part of our course this semester, which will include Units 1 and 2, addresses the judicial function. The choice to begin the course with the judicial function instead of the legislative or executive is partly pragmatic. You're already familiar, maybe painfully familiar, with reading case law, and most of the structural constitutional issues concerning the judicial function are less technical and easier to grasp than some of the interpretive issues that have arisen relating to the legislative and executive branches. The decision to start with the judicial function is also substantive because the Supreme Court historically has taken on the role of the final interpreter of the Constitution, and because basic principles about the judicial function define how and when citizens of the Commonwealth can access the courts to resolve disputes. Let's look first at the constitutional text. The judicial function is established in Article 3 of the Constitution. As you can see, Article 3 is comprised of 3 brief sections. Note that Section 1 vests the judicial function in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. Article 3, Section 1, then, leaves significant discretion to the legislative branch over the exact structure of the federal court system beyond the existence of a Supreme Court. Article 3 also does not mention how Supreme Court justices are selected. That is specified in Article 1, which gives the President the power to nominate and to appoint, by and with the advice and consent of the Senate, judges of the Supreme Court. We'll come back to the Appointments Clause when we discuss the executive power later in the semester. Note also that the Constitution nowhere specifies any age, citizenship, residency, or other requirements, including even a requirement of bar admission to serve on the Supreme Court. However, every justice who has ever sat on the court has been a lawyer, although attending law school did not become a common or necessary part of bar admission prior to the 20th century. Nor does the Constitution place any term limits on justices. In fact, it states that they shall hold their offices during good behavior, which provides lifetime tenure unless they are impeached. Only one justice, Samuel Chase, was ever impeached in 1804, but he was acquitted by the Senate in 1805. In 1968, Justice Abe Fortas resigned under the threat of impeachment because of alleged conflicts of interest and financial improprieties. Of course, other justices have voluntarily resigned or retired for reasons of age or health, as in the most recent case of Justice Kennedy. Notice also that Article 3 does not specify the exact structure of the Supreme Court, including, for example, the number of justices on the court. The number of justices is set by Congress. The Judiciary Act of 1789 set the number at 6. It rose to 7 in 1807, 9 in 1837, and 10 in 1863. It was reduced to 9 again in 1866 in an effort to prevent President Andrew Johnson from appointing new justices. President Franklin D. Roosevelt sought to expand the number in 1937 but failed to persuade Congress. When we discuss the role of the Commerce Clause during the New Deal, you'll see why President Roosevelt advanced this court-packing scheme. As we know from recent history, the nomination and appointment of Supreme Court justices is one of the most politically fraught issues in our republic. I have a small bit of personal experience with this, having served on a team of Seton Hall law professors designated by the American Bar Association to vet the judicial opinions of President Obama's last nominee, Judge Merrick Garland, who was never confirmed by the Senate despite excellent judicial qualifications. For now, note that through Congress's ability to define the court structure and through the appointments power vested in the President and the Senate, as well as through the impeachment power, there are some inherent structural checks and balances on the judicial power. The most basic check on the judicial power, however, is found in Article 3, Section 2, which states that the judicial power shall extend to certain cases and controversies. As we'll discuss in Unit 2, this fundamental limitation of judicial power means that the judiciary is an adjudicative and not a political branch of government. At the same time, we'll read Supreme Court cases on standing, ripeness, mootness, and the political question doctrine, in which the Supreme Court interprets what this limitation means. If the Supreme Court itself is the final arbiter of the constitutional limits on judicial power, are such limits really illusory? That is really the basic question in Unit 1, which covers the principle of judicial review. Our first case in Unit 1 is among the most famous Supreme Court cases ever, Justice John Marshall's opinion in Marbury v. Madison, decided in 1803. The strange procedural posture and somewhat arcane language of Marbury can make it a bit hard to read at first. It's conventionally regarded as the case that establishes the principle of judicial review, although, as our casebook mentions, there were deeper precedents supporting judicial review. Judicial review means that the Supreme Court is empowered to determine whether other sources of purported legal authority violate the Constitution. Many people, and I'm one of them, believe judicial review is essential to the legitimate rule of law. A constitution establishes the most basic structural and substantive principles of a republic. A constitution is by design difficult to change, so that these basic principles are not regularly changed based on the passions of a particular historical moment. If other sources of legal authority, such as statutes enacted by the legislature or legal orders issued by the executive, are not held to a higher constitutional standard, then the structure of law and governance is whatever the legislature or executive decides it is at a given moment, perhaps even in gross conflict with basic constitutional principles. Judges who are insulated from the popular political process are particularly suited to make such determinations. In other words, judicial review ensures that a constitution really constrains the raw exercise of political power in accordance with higher basic principles shared by the people of the Commonwealth. This is what Justice Marshall seems to have meant when he wrote one of the most often quoted phrases in Marbury: "An act of the legislature repugnant to the Constitution is void." But what if the Supreme Court itself interprets or applies the Constitution in a way that's contrary to or inconsistent with the Constitution? Who reviews the results of judicial review? At least if the executive or legislature act contrary to the Constitution, the people can reverse those actions by electing different representatives. Judges of the Supreme Court are not elected and therefore not directly accountable to the political process. Indeed, this is supposed to be a feature, not a bug, of the Article III judiciary. The answer that Justice Marshall gives in Marbury is another one of his most quoted and most disputed phrases. It is emphatically the province and duty of the judicial department to say what the law is. On one reading of this dictum, it is impossible for the Supreme Court to misinterpret the Constitution because the Constitution means whatever the Supreme Court says it means. Of course, this is the complaint of many conservatives today, who advocate for some form of constitutional originalism. They argue that in recent decades the court has strayed far from the Constitution's original meaning, and that a set of hermeneutical principles grounded squarely in text and historical context should constrain judicial interpretation. Progressives and moderates respond that originalism is not in the Constitution itself, was not the assumption of the framers, and is in practice impossible to apply. Many of them suggest that the Constitution is and was meant to be a living document that interacts with contemporary circumstances, but which nevertheless continues to provide inherent limits on the interpretive process. There are many different layers to this debate, but all of it comes back to the notion that the Supreme Court possesses the power of judicial review. In addition to these interpretive debates, another related question weaves through Marbury: the distinction between legal enactments or duties subject to judicial review and discretionary political acts of the executive or legislative branches that do not have the character of laws or duties subject to judicial review. As Justice Marshall notes in Marbury, the province of the courts is solely to decide on the rights of individuals, not to inquire how the executive or executive officers perform duties in which they have a discretion. The Supreme Court is not meant to function in a generalized oversight role over the other branches, even under a broad reading of the power of judicial review or a dynamic theory of constitutional interpretation. The court is supposed to hear particular cases and controversies, not to manage general political questions. We'll get into this more deeply in Unit 2. For now, note that this is another axis to the question of the judiciary's role within a constitutional rule of law. So what was the specific case or controversy in Marbury? What actions of the executive and legislature were at issue? Whose rights were at stake? Think about these questions as you read the case. The notes in our casebook after the case provide some good food for thought, which we'll pursue when we meet in person. This unit also includes Martin v. Hunter's lessee, 1816, Cooper v. Aaron, a 1958 case, and a note on Ex parte McCardle, an 1869 case, and some other related notes. What do these cases and notes say about the scope of judicial review and the role of the Supreme Court in our constitutional system?